common mistake was where both parties are making the same mistake. A mutual mistake is where both parties are making a mistake, but it's a different mistake. And a unilateral mistake is where only one party is making a mistake. The contract will be set aside in a unilateral mistake if the other party is aware of the mistake or should have been aware of the mistake. So I suppose one way of thinking about it is if they had notice of the mistake or constructive notice of the mistake, it's kind of parallel to those ideas of notice or constructive notice. So if one party makes a mistake, if the other party knew of the mistake or should have known of the mistake, then the contract would be set aside. If one party makes a mistake and the other party didn't know of the mistake, nor is it reasonable to expect that they should have known of the mistake, then the contract won't be set aside. So there are several elements to this. Just because there has been a fundamental mistake doesn't mean that the contract will get set aside for unilateral mistake. It'll only get set aside if the second party knew of the mistake or should have known. If it's not reasonable that the second party should have known, then the contract won't get set aside. What test do we use? We use an objective test. So the courts will look and say, objectively, should the second party have known of the mistake? And one of the earliest cases in it is Webster v. Cecil. And that case involved a contract for the sale of land. And there was the mistake related to the purchase price. The original purchase price, or the quoted purchase price, was £2,000. The mistake was contained in a subsequent letter, and the price was put down as £1,250. And so the court concluded that the defendant, that the person seeking to enforce the contract, the plaintiff, should have known that this wasn't the correct purchase price, or in fact he did know that it wasn't the correct purchase price. So again, it's a classic example of a unilateral mistake. It was a mistake as to the price of land, and the court decided that one of the parties to the contract, the purchaser, plaintiff, either knew that it was the incorrect price or should have known it was the incorrect price. I think this case is a very important case. It goes back to the discussion that we had a number of weeks ago about the Aer Lingus seat sale, and it's it's quite a modern case and quite relevant, and it's about internet selling. And the defendant mistakenly advertised printers on the internet for $66 instead of the real price, which was just under $4,000. So probably a technical glitch, but it was an enormous difference, and it was a fundamental mistake. The plaintiff then placed orders for these printers at $66, and as soon as the defendant found out about the mistake, sought to rescind the contract. The court decided that the contracts were void for unilateral mistake because the plaintiff either knew that it was a mistake or should have known that it was a mistake. In that, if there were printers selling for this massive a discount, almost a 98% discount, then it's pretty obvious that it's a mistake. So that's the he should have known an objective test. Applying that to the Aer Lingus ticket sales, the question becomes, did the customers know, or should they have known, that these low prices were mistakes? It can be very easily argued, of course, that in the context of discount of No Frills Airlines and Aer Lingus's move to be a competitor with Ryanair, that it's very feasible that they would have had this massive loss leader to generate publicity and attention, and that would obviously be your defence if Aer Lingus tried to get out of the contract on the grounds of mistake by saying, objectively, a reasonable man would think that this was a valid price. It was just a once-off gimmick to generate publicity. So that brings me, I suppose, to an important point in answering problem questions, which is when that question was asked in class, we hadn't come to discuss the issue of unilateral mistake. But try, when you're answering problem questions, to run through the full gambit of the contractual process and see not just are there issues about the formation of a contract, but are there issues where the contract can be set aside. So in the Aer Lingus case, if you got a problem question on that, was there valid offer and acceptance, and when was there? Was it an invitation to treat, etc.? And then also, could the contract be set aside for a number of reasons, one of which would be unilateral mistake. Okay, I'm just going to turn the projector off for a second to discuss this next topic. So the next section, also under the topic of unilateral mistake, is the way the courts deal with fraudulent transactions. So again, the standard transaction is that A owns a car, B is the fraudster, buys the car off A and gives him a dodgy check. So he buys the car for €5,000 in a check form, and then he owns the car. So the car then rests here. Later on, B sells the car to C, who's an innocent third party, for another €5,000. And then B absconds. So B is then out of the equation. The question then becomes, which of these two, A or C, get the car? No matter which approach the courts take, obviously one of them is going to be down. If A gets the car, C has lost his $5,000 because B's gone with that. If C gets the car, A has lost his $5,000 because B has gone with that. If the courts decide that these contracts are void, if the court decides that the contract between A and B is a void contract, in other words, that it never existed in the first place, that means that B never had any rights under the contract, which means B never had legal title to the car. If B never had any legal title to the car, he could never sell the car to C. So if the contract is deemed to be a void contract, it means legal title has at all times rested with A, it's never moved to B, and it's never moved to C. The opposite to that is that if it's a voidable contract, the contract is a valid and existing contract until it is set aside by one of the parties, in which case legal title goes from A to B, and then legal title goes from B to C. So if it's a voidable contract, C can get rights over the car. Now, obviously I've written up here that B is the fraudster, and C is what's known as equity's darling. C is an innocent third-party purchaser. The technical phrase for it is a bona fide purchaser for value without notice. So he's called equity's darling because under the laws of equity, he's perfectly innocent. He thought he was buying a car. He had no notice that the car was stolen, that there was anything wrong with the title. And equity, whenever we encounter equity's darling, the bona fide purchaser for value without notice, we know that the courts of equity are going to be concerned about his livelihood and welfare. So how does that fit into unilateral mistake? Obviously the unilateral mistake in the contract between A and B is B's identity or B's intentions. So A thinks, A makes the mistake that B is a valid purchaser, which at all times B knows he's not. So that's the unilateral mistake in that contract. And similarly, the unilateral mistake in this contract is again B's identity or B's intentions. So which approach the courts take, we'll look at now. It's not very clear. It's a little bit messy. There's a series of 4 or 5 cases. Some of them fall saying that the contract is void. Some say the contract is voidable. So try to keep this in mind as we go through the next couple of slides.